Welcome to week 2 of LE 101. Right now in front of me on the screen I have a copy of the syllabus, and this is available on the Sakai site under syllabus. It's an attachment, it's a PDF. And this week we're looking at ethics and professional responsibility. So make sure that you read chapter 3, complete the discussion questions at the end of the chapter, which you do not have to submit to me, but if you would like to, I am happy to take a look at them and provide feedback. You also need to post to the week 2 forums. A note about forums, make sure that you remember that you need to post no later than Wednesday to all of the threads that are listed, and then come back on Thursday, Friday, Saturday, and respond to any questions. If you note on the syllabus on page 4, it explains that a little bit more, that you need to make sure to post, and if someone has already answered a question, then you can elaborate on that response, pull out something different, ask another question, something like that. So make sure you have unique responses too. And then make sure that you respond to any questions that I put up as well. Okay, review written assignment 1. We'll take a look at that here in just a minute and complete the chapter 3 quiz. Note that on the syllabus, the week 1 quiz is chapters 1 and 2, so those are 2 separate quizzes, each worth 10 points each. The chapter 3 quiz is worth 20 points, and then next week you'll have the chapter 4 and so on. So here is the Sakai site. I am logged in looking at it as at the student view. If you click on syllabus, there's a copy of the syllabus that you can download. Right, and then announcements, the weekly announcements. We'll come back to resources in just a minute. And then assignments. So here is your first assignment. I went ahead and it's open. This is for this time period, so you can see what it looks like. If you open it up, your assignment is based off discussion question number 1 in chapter 3. So you can read through here, and I give you an example of what I'm looking for as well. And we'll come back and look at this here in a few minutes. Okay. So, chapter 3. Ethics and professional responsibility. A very important area in the law that everybody that works in the legal industry needs to be familiar with. Okay, so for paralegals, there's no universal set of laws, just like paralegal education, as we talked about last week. There is no standardized requirements to be a paralegal at this point in time. There are professional rules of responsibility for lawyers, but remember that the regulation of lawyers is a state issue, and we have 50 different states, so every state can regulate professional rules of responsibility how they see fit. As far as paralegals go, there are voluntary associations that we've talked about, NALA and NFPA, the National Association of Legal Assistants, and the National Federation of Paralegal Associations, I believe. Both of those, if you decide to become a member of them, they do have an ethical code that you have to subscribe to and agree to abide by. And then state statutes exist regarding the unauthorized practice of law that we're going to talk a little bit more in detail about. Okay, so this is one of the professional rules of responsibility for lawyers. This is published by the ABA, the American Bar Association, and the American Bar Association is a voluntary group that lawyers may join. It is a national group. It is not required. Many lawyers do choose to join and be a member to take advantage of the different committees and different programs that are offered to the lawyers, and they also produce a lot of publications and things to keep you updated on certain areas of law. And if you are a member of the ABA, then you have agreed to abide by their ethical rules, which this is one of them. Now, the states, as they regulate lawyers, many of them do look to the model rules of professional conduct that were developed by the American Bar Association and have adopted most of them in full or in part for their states. Okay, so rule 5.3, responsibilities regarding a non-lawyer assistant. So this is the rule for lawyers that employ non-lawyer assistants. So someone that is not a lawyer, so a paralegal or a legal assistant or a legal clerk, whatever terminology they choose to use. So a partner or a lawyer who together with lawyers possess, they have to make reasonable effort that the firm has policies in place to make sure that their non-lawyer assistants are following the ethical rules that are the obligations of the lawyer. So a lawyer must have direct supervisory authority over the non-lawyer and make sure that person is then responsible to make sure that that paralegal is following the rules as well. A lawyer is then responsible for the actions of that non-lawyer. So if they engage in a violation, then the lawyer is responsible as well. If the lawyer orders or with knowledge of the conduct ratifies the conduct, the lawyer has responsibility and is then subject to the consequences involved with whatever that action is. So a lawyer has great responsibility when it comes to practicing law and when it comes to having assistants in the law office to help with them. Basically, the buck stops with the lawyer. The ultimate responsibility lies with them, which can be a pretty big responsibility, and that's why lawyers want to or should make sure that they have very trustworthy people and that they do have policies in place to make sure that they are properly supervising any non-lawyer assistants, as well as just protecting those interests of the client. This is West Virginia Code Section 30-2-4, practice without a license, and what the penalty is. So you could go up to the law library at Mountain State College and pull out the West Virginia Code and read this. And this is the statute dealing with the unauthorized practice of law. So, it shall be unlawful for any natural person to practice or appear as an attorney at law for another in a court of record in this state, or to make it a business to solicit employment for an attorney, or to furnish an attorney or counsel to render legal services, or to hold himself out to the public as being entitled to practice law, or in any other manner to assume, use, or advertise the title of lawyer or attorney and counselor at law, or counselor or attorney and counselor, or equivalent terms in any language, in such manner as to convey the impression that he is a legal practitioner of law, or in any manner to advertise that he, either alone or together with other persons, has, owns, conducts, or maintains a law office, without first having been duly and regularly licensed and admitted to practice law in a court of record of this state, and without having subscribed and taken the oath required by the next preceding section. Any person violating the provisions of this section shall be guilty of a misdemeanor, and upon conviction thereof shall be fined not more than $1,000, but this penalty shall not be incurred by any attorney who institutes suits in the circuit courts after obtaining a license, if he shall qualify at the first term thereafter of the circuit court of any county of the circuit in which he resides. That is a very long sentence, but this is very typical of what a statute issued by the legislature looks like. And this basically says if you are not a lawyer under the laws of West Virginia, so to be a lawyer in West Virginia, you have to have a bachelor's degree. So you have to graduate high school, then you have to have a bachelor's degree. So you go to college to get that, your undergrad. And then you have to attend a approved law school and obtain your JD, your Juris Doctor of Law. And then you have to take the bar examination for the state, which in West Virginia is a 2-day exam, 6 hours of testing each day. And that includes 1 day of all multiple choice questions that are nationalized and used across the country. And then 3 hours of essay questions, and then 3 hours of practical applications. And if you pass that exam, then you are invited to take the oath to become a lawyer for the state. So you have to go to the West Virginia Supreme Court of Appeals on whatever day they say, and you have to take the oath that they require that you will abide by the laws, etc., of the state. That is what it takes to be a lawyer. And then you also have to continue, we have what is called a mandatory state bar in West Virginia. So once you have taken that oath, then you are automatically a member of the West Virginia State Bar. And you have to complete annual requirements, including filings regarding financial disclosures and whether or not you have malpractice insurance, and you have to complete 24 hours of continuing legal education every 2 years, with 3 of those being in ethics and I think one of them being in substance abuse, because that tends to be an issue with people in professions. So if you meet all those requirements, then you are a lawyer. If you do not meet those requirements, then you are not. And if you hold yourself out to be, and you can see all the different terms that they use to try to catch everything, then you would be guilty of violating this statute, along with other potential ramifications depending on what you are actually doing. But if you hold yourself out to be a lawyer when you're not, then you would be subject to this. Okay. So ethical rules for attorneys. As I mentioned, the ABA model rules of professional conduct. The ABA is a voluntary membership, whereas the West Virginia State Bar is a mandatory bar. Some states have what's called a mandatory bar, and some states have what's called a voluntary bar. And so, for example, the state of Ohio is a voluntary bar, but once you go through the process, it's a 2.5-day exam with them, and their requirements are a little bit different. The Supreme Court of Ohio regulates the profession, the legal profession, but then there's also an Ohio State Bar Association, which is a voluntary organization that you can choose to join or not to join. And the ABA is a voluntary one that is a national organization. And we'll look at the resources and links here in a few minutes, but there's a link under there that gets you to their model rules of professional conduct at the ABA. The ABA has also produced a document called the Model Guidelines for the Utilization of Paralegals. So it talks about things that paralegals can and cannot do. And there are 3 tasks. The practice of law is a difficult one to define, but there are 3 tasks that are clearly the practice of law that non-lawyers are not allowed to engage in. One of those is establishing the attorney-client relationship. The second is setting fees, and the third is rendering legal opinions. So you can't be the one who first meets with the client and give the impression that you're the lawyer and set up that relationship. The lawyer has to actually meet with the client. You can't say that, okay, well, we'll do this for you for X amount of dollars. And then, of course, you can't give legal advice. And they seem kind of cut and dry when you list them like that, and they're definitely going to appear on a test and remember them. But there are always questions on whether or not does this exactly fall under there or not. And we'll talk about that more as we go on, and that's really what your first written assignment looks at as well. And then the last bullet point here, approval of paralegal programs. As we've talked about, paralegal programs, paralegal education is not yet regulated in most states. Some states have some specific regulation for different areas of law, but as of right now, there are no official requirements. So, but the ABA has undertaken a process of you can be an ABA approved paralegal education program. Mountain State is not currently one of the approved institutions, and about half of the paralegal education programs in the country are not approved. I think the last time I looked at the statistic, about 40% were. So it's still fairly small, and their requirements have evolved over time and continue to. We've looked at it at different times, and the incorporation of online classes, such as this one, has been, it's now somewhat allowable. When they first issued the guidelines, online education was not an option, but it is only allowed for a certain percentage of the courses, and it'll be interesting to see how this evolves. It might eventually become the norm, it might stay as is, but you can read more about that if you have interest. Ethical Rules for Paralegals from NALA, the National Association of Legal Assistants. Appendix C in your book has the Code of Ethics and Professional Responsibility. The highlights: a paralegal must not perform any duties that attorneys only may perform. A paralegal must not engage in UPL, which is the unauthorized practice of law. UPL is the abbreviation for that, the acronym. A paralegal must strive to maintain integrity and a high degree of competency. A paralegal must protect client competences. A paralegal must use discretion and professional judgment commensurate with his or her experience and knowledge. And Appendix D of your book has the model, standards, and guidelines for the utilization of legal assistants and paralegals that you can look at. And as you read through your text, you'll see more examples and explanations of what these mean, and some real-life kind of situations where they do come into play. NFPA, the National Federation of Paralegal Associations model of Code of Ethics and Professional Responsibility, has similar requirements. A paralegal must achieve and maintain a high level of competence, so that means that you have gone and educated yourself, whether it's through a formal program, whether it's through private education, continuing education, working closely with the lawyer, and etc. A paralegal must maintain a high level of personal and professional integrity, so this is not, you don't have a client come in and share their story and then you immediately put it on Twitter or something. A paralegal must serve the public interest by contributing to the improvement of the legal system. A paralegal must preserve all confidential information. Very important, kind of goes back to the Twitter example. A paralegal must avoid conflicts of interest. So if you help, say, Joe and Bill have a business together, and you help both of them and you learn things about both of them, and then they have a falling out and Joe decides he wants to sue Bill, you can't then go represent Joe as he sues Bill, because you already have a conflict of interest, because you have information that you would not have otherwise had about Bill by the previous representation. And a paralegal must not engage in the unauthorized practice of law, UPL. And those three things we listed before are the kind of hallmarks of what UPL is. Duty of competence. Ordinary skill and knowledge that would be expected of similar paralegals in similar circumstances. And attorneys, that's the standard. And most statutes and things that you'll see will have a standard of what the person should be held to. Attorneys and paralegals are not expected to know all of the law, but they are expected to be able to know how to find the law and when they need to ask for help. So there is a lot of information out there, so it's impossible to know anything and everything, but legal professionals are supposed to know how to research and find that information, and to not just make something up or guess, and to know when they need to seek out help or refer something out if they don't know it. Some common pitfalls. Failure to be thorough. You get too busy to give the attention needed to every case. You've got a stack of files in front of you and a lot to get done, and you try to cut corners, in which case you might be shorting your client the attention it deserves and engaging in legal malpractice for failure to do what you need to do. Failure to complete work on time. Clients do not understand the complexity of a task. There might be delays outside the firm's control, like a crowded docket at the court where things get pushed back, mismanagement of time in the office, or you spend too much time on Facebook instead of doing what you need to do during those business hours. Errors related to carelessness. You just get too busy, but you need to remember to check, double check, and proofread everything, especially things that you're submitting to anywhere really, but to clients, to opposing counsel, to the courts, to make sure that what you are putting out there is what you want to put out there. Legal services are very expensive, so clients expect quality to come from it, so carelessness is not acceptable. Duty of integrity. Engaging in ex parte communications with the court, that means that you're having discussions with the judge outside of court when you shouldn't. So you have a case before a court and it's still going on, and then that evening you go out to dinner and you see the judge having dinner with his family or something, and you decide to start going over and talking about the case. That is an ex parte communication, and that is illegal. It's not allowed. It can result in things like a mistrial and being held in contempt. Communicating without prior consent with a party represented by counsel. So if you represent Sue, and Sue is suing Ann, and you see Ann out, and you're like, if Ann just understood, we could just settle this and get it out of the way, and you know Ann has a lawyer, you can't go and just talk to Ann. You have to talk to her lawyer. And that's to protect Ann from being influenced by someone who might be able to use fancy legal language kind of thing and convince them of something else. Preparing dishonest and inaccurate time and billing records. Legal services are expensive. So make sure that when you are doing your billing that you are accurately documenting your time, and not just saying, well, we'll increase it a little bit here and a little bit there to meet whatever billable requirements you might have, or to just try to make some extra money. Same thing as inflating hours. Inflating hours means, well, I worked for 5 minutes here, we'll just call that a full hour. Most attorneys do have policies regarding billing, and your legal malpractice carriers will also have requirements there. Most of them require you to bill to every 6 minutes to keep track of what you're doing, which sounds a little crazy, but there are lawyers that charge $500 an hour, so 6 minutes can be expensive enough. Failing to be honest and scrupulous in maintaining funds. You have access to client funds, whether it be for expenses or whether it be an award from a court. So you have to be honest and make sure that you are properly maintaining those funds. And failing to report wrongdoing by other parties. You might be doing everything right, but you know that someone else isn't, and they're engaging in one of these practices. Then you have a duty to report that. Duty of confidentiality. In order to adequately represent a client, you need to have full disclosure from them. So they need to be able to trust you, and they need to be able to tell you everything, even stuff that might be unfavorable to them. So they have to have complete trust there, because you don't want to find out information from the other side. You don't want to find out information from while you're in court that might be damaging to your case. You need to know it ahead of time so you can prepare appropriately. ABA's Guideline 6, it's the attorney's responsibility to ensure that clients' confidences are preserved. And usually there's a confidentiality agreement that you have to sign when you work for a firm, saying that you'll keep everything to yourself. And that means not going home and talking to your spouse, your girlfriend, your boyfriend, anyone, your best friend kind of thing. These are not good stories to go tell and be the life of the party. You have to keep things confidential. ABA Rule 1.6, you cannot disclose information without informed consent. So informed consent means that the client fully understands what the ramifications are of disclosing certain information, and they have signed off on it. The attorney-client privilege is a protected privilege that most of us have probably heard of. An attorney cannot be then subpoenaed to testify against their client if the privilege has been sustained and not broken. Work product doctrine. Notes, memoranda, or other documents prepared in anticipation of litigation are not discoverable by the other side. So there are some fine lines that you have to be careful of when you're preparing documents and such that are the work product of the attorney, if they are the mental thoughts and notes of the lawyer rather than a product that is developed for litigation. So another tricky line. You can take a look at page 58 in your text, and it gives you some tips of how to be careful not to have any inadvertent disclosures. Okay, metadata. This is less of a wow factor than it used to be. Most people are understanding what it is and what the effects are. It's information that's describing the history, management, or tracking of information created on a computer. So if you look at a document like Microsoft Word, if you have a document on there and you, so maybe you're writing a letter to an opposing party before litigation actually happens, or you're writing something for the court and you have information in there and then you find out, oh, this is damaging or this is wrong, or you have some sort of inadvertent disclosure there, and then you go through and you erase it. So you save it and then you go back and you're like, oh, I need to make changes to here and there. Metadata records those changes, so it tells you what changes happened when and what time, and it keeps a record of them. There is a link about metadata, and you can see why it can be an issue. And virtual discovery is becoming much more common, so taking someone's laptop and looking and seeing everything that has happened is becoming more of a common way of practice because we keep too much on the computer. So you need to be aware of that. Everybody just needs to be aware of that, especially in a litigious field. Duty to avoid conflicts of interest. You can't represent adverse parties, opposing parties in a case. This applies to current and former clients. You can take a look at the ABA Model Rule 1.7 that talks about it. If an attorney reasonably believes he or she will be able to provide competent representation to all parties, and each client gives informed consent in writing, you can do that. And that might pop up if you have an amicable divorce where both parties don't want to pay the expense of having an extra lawyer and everybody's getting along and such. But if things fall apart later, then that lawyer would not be able to represent either of them, and they both would have to go find a new one. Or maybe in a real estate transaction, the different interests aren't that adverse and they want to just use one lawyer, then that can happen. But again, if things would fall apart and they would become opposing, then the attorney couldn't represent either of them. ABA Model Rule 1.9, an attorney who previously represented a client may not later represent another person in the same or a substantially related matter if that person's interests are materially adverse to the interests of the former client, unless informed consent is given. So that means that you can't represent Donald in this case, and then later on maybe Donald was suing a pharmaceutical company for saying that drugs did something bad to him or something, and then later you can't go on to represent the pharmaceutical company knowing the information that you had by being opposing counsel. Okay, other situations, Model Rule 1.8, business transactions. If this is meaning business transactions between a client and a lawyer. The client has to give written consent and be fair, so if you want to go into business with a client. And they have to be advised to seek independent counsel, another lawyer. Gifts in general cannot be received. You can receive, your box of Hall's chocolates at Christmas, but you can't get a substantial sum of money or a piece of property or something like that. Media rights, meaning writing a book about the case kind of thing. So think O.J. Simpson and all the books that were written about that. You can't get media rights until the representation ends and the case is over and the attorney-client relationship is ended. Financial assistance. Attorney may advance court costs, but they can't do any other assistance. So frequently a lawyer will do a contingent fee agreement where the idea is that they only get money if they're successful, so they might agree to advance court costs to someone that cannot afford to pay for those costs of filing, the fees, the cost of postage, etc. Payment by others. So if Billy gets into trouble and his dad wants to come and hire you to represent him, there has to be informed consent that you are going to be representing Billy and not Dad in terms of what the choices are going to be made. Scope of conflict and career mobility. The doctrine of imputed conflict or imputed disqualification is basically saying that if someone in your office has a conflict and you have this case, then you assume that everybody is exposed to that conflict. So the things that you can do are erect an ethical barrier or an ethical screen so that everybody working on the case in writing is aware that they're not allowed to share information with this person. So this happens, and frequently in small towns, it's something to be aware of, where you're switching between one firm and another, and maybe they have a case against one. You were working for firm A and you moved to firm B, and firm A and firm B have adverse interests in a case, and obviously you can't switch sides and work for the other side. But it doesn't mean you can't not work there. It just means they have to take certain precautions to make sure you're not privy to the information offered. Conflicts check. There are more electronic systems now for checking conflicts than manually checking them. In the old days, it used to be something like a Rolodex of clients, and then you'd go through and try to check to make sure that there's not a conflict. So maybe you represented Tina in her divorce and to her divorce from Alan, and then you have someone that comes in and you were privy to confidential information of that divorce, but now they want to sue, and that information could be relevant in that case, so then you would have a conflict. So you want to keep track of who the client's relatives are, their employments, etc., employees, their companies that they're involved with, and then compare with your client list to make sure that you're not going to find a conflict as you go. Communication with adverse parties. As I mentioned before, you can't contact a represented person without the lawyer's consent, and this is to make sure that legal professionals do not attempt to take advantage of adverse parties. Financial matters, sending fees, they have to be reasonable and in writing. Segregating client funds, you have to have 2 bank accounts and keep track of those clients that are paying you hourly, those that are paying a flat fee, or those that are paying a contingency. So an example for hourly work might be, I need you to draft this real estate agreement for me, so how many ever, it takes me 5 hours to do that, so I will bill you for 5 hours. Flat fee, I want you to do a simple will for me, and we charge $500 to do a simple will, so you just pay that. Contingency is the one that's based upon whether or not you prevail or not. Retainers are money that is paid up front by the client for the lawyer to draw from expenses. So as maybe you're doing a contingency fee case, but many lawyers will still require a retainer of X amount of dollars so that you can pull from it to pay for the filing fees at the court, or for a private investigator, or for postage and just office supplies and that kind of thing. Trust accounts, you have to keep client funds separate from your operating accounts. So like on that retainer, if you have $1,000 put into a retainer for client A, you can't just put that into your regular operating account. You have to set it aside, and then you have to bill to that account and pull the money over. Client funds have to be kept separate and protected. The IOLTA program is I can't remember what the acronym stands for right now, but you can look at Figure 3.4. It's basically a program where any interest that is obtained from those trust accounts is then donated. If it's a nominal amount, they're all added together and then donated to an association, like a nonprofit type thing that supports low-income individuals and helping to provide legal services for them. Fee splitting, that's a state issue in West Virginia. You're not allowed to split fees with non-lawyers. Other states have different rules. Billing practices, just make sure you're honest. Solicitation and advertising, lawyers always have a great reputation here. Sarcasm. Ambulance chasing is not allowed. You can advertise as long as it's not false, misleading, or constitutes improper solicitation. There was a guy, I think in Ravenswood, that had an advertisement at one point that said if he couldn't get you off your drunk driving charges, then he'd buy you a bicycle, that kind of thing. So he's usually been a good poster boy for figuring out what's okay and what's not. Those are going to be state rules as well. The concern is with non-lawyers, the perception that's created with potential clients about the legal profession, which has its problems. So make sure you check your state rules. There is a duty to avoid UPL, the unauthorized practice of law, which we talked about. You can't do it without a law license. You can't engage in the practice of law without a law license, and kind of lay those out again. And you can read more in your text, and the assignment 1 talks about those. So whether or not it is the practice of law. Some questions to look at is whether the activity is one traditionally performed by an attorney, whether the activity requires professional judgment and legal skills not commonly possessed by lay persons, non-lawyers, and whether harm has been caused to the consumer of service or activity. Okay, so what is permissible? There are some state and federal administrative hearings where non-lawyers can represent people. Other activities, communication is obviously fine so long as the paralegal status is clear, so you make sure that the client understands that you're a paralegal and they understand what a paralegal is, and that means that you're not a lawyer. Relaying advice so long as the client's aware it's from the lawyer, so you can kind of give a message from one to the other, but you can't elaborate on it or answer interpretation questions that would be legal advice. Preparing legal documents, you can do that under supervision, so you prepare the draft and then the attorney will sign off on it. Same thing with conducting research and meeting with clients as long as the client is aware. Page 71 gives you some other examples. Some clearly prohibited tasks, you can't give legal advice. Page 70 has some examples of that. You can't agree to represent the client, you can't establish the fees, you can't sign the legal documents, you can't conduct a deposition, you can't sign the documents to be filed into court, and you cannot negotiate the settlement. Avoiding UPL. Make sure that you disclose your status, making sure the client is informed of who you are and what that position is within the firm. Just saying I'm a paralegal might not be clear to some person that might not have knowledge of what a paralegal is in comparison to a lawyer. They might assume it's the same kind of thing. And make sure that you request supervision. Sometimes lawyers are not the best about supervising as they should, so make sure that you make them do that job. Freelance paralegals and independent paralegals. This is not really that common in West Virginia. It's not really allowed, but there are some states that allow paralegals to do that. Basically, it's working on your own on certain cases, but you still have to abide with those supervision rules. So this is a tricky one. In West Virginia, it doesn't really happen, but there are other states that will allow it. Duty to report misconduct. If you know of a violation, basically you need to report it. And so review the ethics code, don't participate and report your concerns, and if you belong to one of the paralegal associations, they're a good resource to discuss. Consequences of violations. We looked at the UPL statute. It is a misdemeanor and it can lead to a conviction and fines. On the lawyer's part, legal malpractice can result in civil liability, so a client could sue you for money. And then the state bar, the West Virginia State Bar, has an office called the Office of Disciplinary Counsel, and complaints filed with them can result in restitution. So say you don't abide by those financial rules and you take money that doesn't belong to you, then you can be ordered to pay them back. It can result in continuing education requirements where you have to go take some classes on this or that because you weren't following the rules. It could be a formal reprimand. You could end up having to be on probation, not being able to practice law. You could be forced to be under supervision, so another lawyer has to watch after you. You could be suspended from the practice of law, and the ultimate one is disbarment, and you could have your license taken away. Okay. I think that is it for week 2. If you have any questions, send me a message.